November 20th, 1945. The lights inside the Palace of Justice in Nuremberg came on before dawn. Cleaners had finished their work hours earlier. The translators were already at their stations, adjusting headsets that had never been tested at this scale before. Guards stood at positions they had rehearsed, but never performed in front of a watching world. And somewhere in the corridors behind the main chamber, 21 men in suits waited to be brought into a room that would either define justice or expose its limits. Nobody in that building, not the judges, not the prosecutors, not the defendants themselves, knew for certain whether what was about to happen would hold together. That is the question this episode sits with, not whether the men in the dock were guilty. The records on that are extensive. The question is simpler and harder. Could a courtroom, built inside the rubble of a war that had destroyed every prior assumption about law, actually function as a court? Room 600 was the answer, or the attempted one. Let us go back to the room itself. The Palace of Justice in Nuremberg had survived the Allied bombing campaign well enough to be usable, which was part of why it was chosen. American forces had taken the city in April 1945. By August, the four Allied powers, the United States, Great Britain, France, and the Soviet Union, had signed the London Charter, which established the legal framework for what they were calling the International Military Tribunal. They needed a location with courtroom space, holding cells nearby, and enough structural integrity to function. Nuremberg, despite being a city of rubble outside its walls, had the Palace of Justice. Workers spent weeks converting a large chamber on the second floor. They expanded it. They installed a simultaneous translation system that had never been deployed in a legal setting before. 4 languages were going to be spoken and heard in real time inside that room: English, French, Russian, and German. Each participant wore headphones. Each seat had a dial. Prosecutors, judges, defendants, journalists, and observers would all be receiving the same proceedings in different languages at once. That system alone was an act of invention. There was no template for it. The room seated around 250 people when full. The press gallery was heavily occupied from the first morning. Journalists had come from across the world, including some who had covered the war itself, and were now watching its principal architects face a legal reckoning in formal business attire. The defendants sat in 2 rows along one side of the room. They had been stripped of their uniforms. That detail mattered. The prosecution had made a deliberate choice to present these men as individuals, not as symbols of a collapsed military structure. A uniform carries rank. A suit places a person in civilian life where ordinary law applies. The argument was being made before a single word was spoken. Among those present on that first morning were men whose names had been known across Europe and beyond for years. Hermann Goering sat in the front row. He had lost considerable weight during his detention, a fact that several journalists noted in their dispatches. He had been commander of the Luftwaffe, president of the Reichstag, and at one point the designated successor to Hitler. Rudolf Hess, who had made his strange individual flight to Scotland in 1941, sat nearby. Joachim von Ribbentrop, the former foreign minister. Wilhelm Keitel, head of the Wehrmacht High Command, Albert Speer, Minister for Armaments, Karl Donitz, who had briefly led Germany after Hitler's death, Hans Frank, who had governed occupied Poland, Julius Streicher, publisher of the anti-Semitic newspaper Der Stürmer. 21 men, each with a name card, each with headphones, each with a different legal strategy forming behind their eyes. The charges against them were organized into 4 counts. The first was conspiracy to wage aggressive war. The second was crimes against peace, meaning the actual planning and launching of wars of aggression. The third was war crimes, violations of the laws and customs of war as they had existed before 1939. The fourth was crimes against humanity, a category that addressed what had been done to civilian populations on a scale that no prior legal language had been adequate to describe. That fourth count was the one with no precedent. The term crimes against humanity did not begin at Nuremberg. Scholars have traced its use back to the Allied Declaration in 1915 regarding massacres of the Armenian population in Ottoman Turkey. But it had never been codified, never been made the formal legal basis of a prosecution. What the Nuremberg Tribunal was doing by including it was asserting something that existing international law had not asserted before, that a government's treatment of its own citizens, if conducted on a sufficient scale and with sufficient deliberate intent, was a matter for the international community to adjudicate. That was a significant claim. Several of the defense attorneys challenged it immediately. Their argument was that you cannot prosecute someone under a law that did not exist at the time the act was committed. The legal Latin phrase is nullum crimen sine lege, no crime without a law. The tribunal was going to have to answer that challenge before the proceedings could be taken seriously as law rather than as organized punishment. The presiding judges knew this. The bench was composed of representatives from each of the 4 Allied powers. Lord Justice Geoffrey Lawrence of Great Britain served as president of the tribunal. Francis Biddle represented the United States. Henri Dondieu de Vabre represented France. Iona Nikitchenko represented the Soviet Union. At 10 o'clock on the morning of November 20th, Lawrence opened the session. His language was formal and careful. He acknowledged that the trial was unprecedented. He did not claim otherwise. He stated that the tribunal was constituted under the authority of the London Charter, which represented the agreement of 4 sovereign governments. He made clear that the proceedings would follow rules of evidence and procedure, that defendants had the right to counsel, to call witnesses, and to examine the prosecution's evidence. He was, in measured language, making the case that what was about to happen was a legal process and not a performance. Whether the room fully believed him was another question. Several of the defendants had already made clear through their attorneys that they rejected the legitimacy of the court. Goering, in particular, was understood to have significant tactical intelligence and no intention of being managed. His demeanor on that first morning was described by observers as engaged, almost curious, as though he were watching the proceedings from outside them while sitting in the middle of them. Robert Jackson delivered the opening statement for the American prosecution that afternoon. Jackson was an Associate Justice of the United States Supreme Court. President Truman had asked him to serve as chief American counsel at the tribunal, and Jackson had shaped the prosecution's approach more than any other individual. His opening statement ran for several hours across the afternoon of November 20th and into the following morning. The section delivered on that first day is one of the most studied pieces of legal rhetoric in the 20th century. Jackson began by acknowledging the difficulty of the position the tribunal occupied. He said, in substance, that the 4 Allied nations were both the victors in the war and the parties now sitting in judgment, and that this created an obligation rather than a license. He argued that the prosecution owed it to the legitimacy of the proceeding to rely on documents, on the accused's own records, on the internal communications of the Nazi government itself. He was promising the tribunal and the watching world that the case would be built from the inside out, from German files and German orders and German signatures. That was not a rhetorical flourish. It was a strategy with an archive behind it. Allied forces and investigative teams had spent months gathering documents. The Nuremberg prosecutors had access to an enormous volume of captured German administrative material. Orders, correspondence, meeting minutes, organizational charts, planning documents. The German bureaucratic habit of writing things down, of filing and cross-referencing and copying up the chain of command, had left a paper record that the prosecutors intended to use as the primary foundation of their case. Jackson described the charges not as a judgment imposed by outsiders, but as a case built from the defendant's own hands. He said the surviving records of the Nazi government were among the most damning exhibits the prosecution possessed. He also made an argument that stretched beyond the individuals in the dock. He said that if the tribunal allowed aggressive war to go unpunished, if it allowed the deliberate murder of civilian populations to be treated as something beneath the reach of law, then the precedent set would not be one of justice, but of silence. He argued that future generations would inherit either the framework the tribunal was trying to establish or the absence of one. That was the weight he placed on the morning. By the time the first session adjourned, the translation system had functioned without catastrophic failure. The defendants had sat through hours of charges being read. The press had filed dispatches. The judges had maintained order. None of those things had been guaranteed when the lights came on before dawn. If this kind of document-led, testimony-driven history is what you come here for, subscribe for the next file. Room 600 follows the evidence and nothing else. What came after that first morning was months of procedure that tested everything Jackson had promised. Documents were entered into evidence. Witnesses were called. The defendants were cross-examined. Some of them performed in ways that no one had anticipated. Goering, under cross-examination by Jackson himself, demonstrated that he was willing and able to fight back. He challenged interpretations, disputed translations, and managed at several moments to shift the dynamic in the room in ways that made the proceedings feel less like a smooth exercise in accountability and more like a genuine legal contest. Jackson, by most accounts from observers at the time, found the cross-examination difficult. Other prosecutors had more success with different defendants. The defense attorneys, some German and some brought in from other countries, filed motions, challenged the Charter's authority, and tried to introduce evidence that the Allied powers had themselves committed acts that would fall under the same legal framework being applied to their clients. The Soviet Union's involvement in the division of Poland in 1939 was raised as one example. The tribunal ruled these arguments inadmissible in various ways, but the fact that they were made at all showed that the legal structure was under genuine pressure from within. That pressure was part of what made Nuremberg more than a formality. Its critics then and in the decades since have pointed to real tensions in its design. A court in which the victors judge the defeated carries structural problems that do not disappear because the defendants receive legal representation. Those problems were recognized at the time, including by some of the people involved in building the tribunal. What the records also show, however, is that the standards applied to the defendants produced genuine acquittals. 3 of the men charged were found not guilty and released. That matters. A process designed simply to convict would not have generated acquittals. The tribunal was not a rubber stamp. It was imperfect, contested, and incomplete in what it addressed, but it was a functioning legal body. The verdicts came in October 1946. 12 of the defendants received death sentences. 3 received life sentences. 4 received shorter terms. 3 were acquitted. What happened in room 600 between November 1945 and October 1946 did not resolve the questions it raised. No trial could have. The scale of what the Nazi government had done was so large that a single tribunal, regardless of its quality or duration, could not account for all of it. Hundreds of thousands of victims had no direct representation in those proceedings. Many perpetrators were never charged. Many survivors had no formal role in a process that concerned them more than almost anyone else in the building. Those gaps belong to the record too. What the first morning established before the arguments and the evidence and the verdicts was that the attempt would be made. That law would be asked to answer for what armies and governments had done. That the language of accountability, however imperfect, would be spoken aloud in a room with defendants present, with evidence on the table and with the result recorded. The translators in their booths adjusted their headsets. The judges took their places. The lights were already on. The files were open. And for the first time in the history of international law, a court convened to hold a government responsible for what it had decided to do to the world. That is where this story begins. The next episode opens the files on what those first weeks of testimony actually revealed, and on the moment when the documentary evidence started to land harder than anyone in the room had prepared for.